I'm not quite sure what memorandum was enclosed. I think I have a copy of that. So it looks as if the court has acceded to an application to reopen the pleadings for the purposes of some further essential defence on the jurisdictional issue. Anyway, there we are. Now, I also received on my iPhone a copy of the timetable that had been kindly prepared in response to my request, which I'm grateful. It's almost too small to read, but I will. I've made my own timetable, and hopefully it's roughly right. If I make an error, no doubt either it'll be unimportant or it can be corrected in due course. Now, Mr. Abbott, yes.
My Lord, I'm grateful. I don't know if there's any particular areas that you'd like me to focus on following my learned friend's submissions, but I was intending to deal with the decree first and then Article 60.
I'm perfectly happy to take it in that order, of course.
So, in relation to... can you hear me? I think we have an echo here.
Yes, I can hear you loud and clear, thank you.
Excellent. In relation to the decree, as has already been mentioned, it appears to be common ground for the experts that the judicial authority is the sole authority authorised to determine conflicts of jurisdiction between the Dubai courts and the DIFC courts after the 9th of June. The primary position of my clients is that it's unnecessary to apply the decree retrospectively, as there is no conflict of jurisdiction. And the secondary position is that the decree, if that is not right, then the decree does apply retrospectively to pending cases because it is a procedural law. So perhaps if I can go to my...
I mean, your point is, as I understand it, that whatever may be the jurisdiction, the effect of the decree is to eliminate the jurisdiction of the USC.
That's correct. In relation to, obviously in relation to the Dubai court and the DIFC.
Oh, yeah. And can you just help me a little bit as to how a decree of the Emirate of Dubai can effectively amend a federal statute?
Yes. As your Lordship alluded to in the discussion with my learned friend, it may be that there has to be an amendment to the USC law itself.
Or alternatively, it can be left there, and I suppose that the committee may well effectively catch most of the jurisdictional disputes, but I'm some difficulty of seeing how one can amend a federal statute with an individual emirate decree. Anyway, there it is.
I take your point, but the experts in this case have agreed that it is the sole authority.
Yeah. Right.
But
Well, assuming for the moment that that is its impact, because the effect, if you're right, is that I have no jurisdiction, correct?
Well, the effect, as we say, is that the application...
Well, in a sense, that the application to... pursuant to Article 60, or rather to stay by virtue of Article 60, fails in limine because there's no jurisdiction of this court to have regard to Article 60 because Article 60 has no application.
That's correct.
Yes. Well, it's a fairly striking proposition. And as I've already indicated, I have some concerns as to whether I got adequate help on the relationship between the laws of an emirate and the federal laws. And my caution is enhanced by concerns as to the impact of such a decision on other cases.
Yes.
But there it is. There's nothing more you want to add on the topic?
Not at this stage, my Lord,
Right.
although I may touch on that point when it comes to the latter part of my submissions, and you'll see I've referred to a floodgates type argument, which may be what you're thinking of.
Well, not so much a floodgate, just a concern as to whether the court is approaching matters in the correct way. So retroactivity, yes.
So in my submission, and this is supported by the expert report of Dr. Muller, perhaps we should go to that at tab 7, page 59, paragraph 18.
Thank you.
It is, and you'll see at paragraph, at the last sentence of paragraph 18, sorry, the penultimate sentence says, hence the decree is not being applied retrospectively as no conflict of jurisdiction has arisen. And then the second sentence goes into support the secondary position. What we say is this is not a retrospective application of the decree, as the law is to be applied after the alleged conflict has arisen, which we say has not arisen yet, and by which time, of course, the decree will be in effect, came into effect, even on the applicant's case on the 9th of June 2016. So that, in essence, is what Dr. Muller and we are saying in relation to that's our primary position. If there's nothing else that I can help you on that, our secondary position, and if the court determines that a conflict of jurisdiction has already arisen, which is contrary to our primary position.
Understood.
Our position is that the decree does apply retrospectively, as given its procedural nature, for the reasons explained in Dr. Muller's report, and I don't want to go over ground that my learned friend has already referred you to, but the relevant paragraphs of Dr. Muller's report are paragraphs 15 to 19, but perhaps I can address the point that your Lordship raised in argument from my learned friend in relation to the close of pleadings. I'll deal with that point first, and then I'll deal with the application.
Well, before you deal with that, can we just get a handle on the relevance of the Civil Procedure Code, which is a federal law, correct?
That's correct. That's correct.
And it's a federal law that is expressly is excluded from the DIFCC.
I accept that. I accept that,
Your
Lordship. What the applicant says in his skeleton at paragraphs 23 to 24, it might be useful to have a look.
Yeah.
Is that he accepts that the decree. Sorry, do you have that, Your Lordship?
Yeah, I have it.
He accepts that the decree makes express reference not only to the Dubai courts but also to the DIFC courts, and then seeks to argue that the laws passed by the ruler of Dubai in relation to the DIFC courts are governed by DIFC law and not by the Union civil law, and then refers to a number of laws, only one of which actually is in the bundle. That's law number 9 of 2004. I submit that this is misconceived because Decree 19 is a Dubai law decree, which, as the applicant has stated here, applies to both the onshore Dubai courts and the DIFC courts. It's not directed at the jurisdiction of the DIFC, but at the jurisdiction of the new judicial authority itself, and that's clear from the face of the decree. I'll just get you the reference, my Lord. The decree is at tab 11.
Yeah.
Page 105, heading at the top of Article 2 is jurisdiction of the judicial authority.
Yeah.
And that, in my submission, is also reflected by the makeup, as has already been noted in argument, on the prior page 104, the makeup of the Judicial Committee, which comprises both members of the Dubai and the DIFC courts.
Yeah.
The laws referred to by my learned friend at paragraph 23 of his skeleton are a mixture of Dubai law, federal law, and DIFC law. And if you look at those laws in my submission, they and the provisions that he has cited relate to the DIFC court carrying out its functions in accordance with the Centre's laws. They also refer to the application of substantive governing law. That's law number 12 of 2004. Law number 10 of 2004, the references to the DIFC court's own jurisdiction. And in paragraph 24, there's also a reference in the context of the IGPL decision to law number 8 of 2004, which is the federal law that disapplies the UAE civil and commercial law. So my submission is that none of these laws deal with the situation we've got here, where the decree applies to both DIFC and non-DIFC UAE courts. And the decree neither confers nor takes jurisdiction away from either of those courts.
Yeah, but the thrust of your proposition is that because it is a procedural law within the meaning of Article 1 of the Civil Procedure Code, it follows that is retrospective. But what I'm not at the moment fully understanding is how you say that Article 1 of CPC is applicable to the scope of the new decree, vis-à-vis at least the GIFC.
My Lordship, in my submission, it's a Dubai law decree. It's not a standalone DIFC law.
Correct. I'm not arguing or even suggesting to the contrary. I'm simply asking how you use Article 1 of the CPC to determine whether the Dubai decree is retroactive.
Well, in my submission, that because the judicial authority is not solely a creature of DIFC law, then Article 1 of the CPC does apply.
Okay, I understand.
And the decree only takes away or relates to the current jurisdiction of the USC, not the DIFC.
Okay, thank you. I understand the point.
Perhaps I'll then address the point that was raised. In argument by my learned friend in relation to the close of pleadings, and in fact raised by your Lordship, that the DIFC court's pleadings had closed. That is correct. In my submission, the critical point is that the pleadings have not closed in the USC, and I don't think that's a matter of dispute.
Sorry, let me just understand that. The
if you have the chronology, my Lordship, I can.
I don't. I'm so sorry. I've just lost my. Where's the reference to pleadings being closed?
That is in Dr. Al-Muller's report. Is that tab 7?
Yeah. That page.
Page 58.
I've got that.
Paragraph 16.
I've got it now. So sorry.
That's okay.
What I was.
And paragraph. My colleague's telling me paragraph 10 of your skeleton as well.
Thank you. So I was looking at Article 1 in divider.
There is a translation of Article 1 in the authorities bundle.
Yeah, right at the back.
That's correct.
Which, as I understand, doesn't make any reference to close the pleadings. Or maybe I'm reading it wrong.
I think it's. Do you have it? It's document 220 at the back.
I've got it, yeah.
Okay, so...
So where's the reference to close of pleadings?
It's in A. So we'll have after 1 we have the wording says excluding A, laws amending jurisdictions where they become effective after the closing of the case.
Oh, after the closing, yeah.
So that's where the...
so you say the amending jurisdiction. So what is the law amending jurisdiction for this purpose? Presumably the decree.
That's correct. That's correct.
Yeah. And what we're considering is the retroactivity of the decree. And the question therefore arises as to whether the decree, which is the law amending jurisdiction, became effective after the close of the case pleadings. Presumably that's a reference to the cases which give rise to the potential conflict. It's nothing to do with the USC, is it?
Well, in my submission, it is because the decree applies in respect of the USC petition, and it doesn't matter that the pleadings are closed in the DIC court.
Okay. Thank you. Right. So that's retroactivity.
Yes. If I can one 10 seconds, Your Lordship.
Yeah, sure.
Sorry, Your Lordship. Yes. That's my position on submissions on retroactivity.
But you say the argument about retroactivity and the impact on Article 60 is by the by, because there is no conflict, and therefore one doesn't have to invoke 60 or, for that matter, the decree.
That's correct, Your Lordship, and it may be an appropriate point to come on to Article 60.
Right.
As Your Lordship has remarked, it is, to use Your Lordship's words, a remarkable proposition that's being advanced by my learned friend here in relation to their argument that there is currently a conflict of jurisdiction. And I'm looking at paragraphs 14 onwards in my skeleton argument. In my submission, there must be clearly a higher threshold to trigger Article 60 than there simply having been filed claims before two judicial authorities, as the applicant suggests, and as Your Lordship expressed surprise, if I can put it at that proposition, and describe it as a godsend to litigants who, in my submission, wish to delay and disrupt proceedings. We say there must be two either positive or negative decisions of judicial authorities confirming or declining jurisdiction as set out in the text of Article 60, and that's clearly not the case here, because as was the case for the hearing today, and as is still the case, the Dubai Court has yet to issue a decision on jurisdiction. They've just adjourned the proceedings today until August. Perhaps if I can just cover off one point that was raised in argument in relation to the USC case number 10 of 28.
Yeah.
There was some discussion as to where the reference in Allianz may have come from.
Yes.
If we turn to the decision, which is at tab 13.
I have it.
Page 128.
I have it.
Number 1, and there's a phrase in inverted commas, international jurisdiction. Dispute of jurisdiction of the Supreme Court, and the next two lines reads, jurisdiction of the Supreme Federal Court to decide in the dispute of jurisdiction between two final judgments. Now, I don't know, but that may be where that reference in Allianz and IGPL has come from. Of course, I appreciate.
Yes, I see.
As your lordship has
So
said,
this is this part of the decision, or is it some head note? No, it looks like part of the decision.
my lord,
Not as I.
we are obviously reading an English translation of the, and I accept that, of the Arabic original. I'll see if I can take instructions on that whilst we're here.
Yeah.
We have the experts from before.
Well, it starts with the figure 1. There's no 2 in there, which is slightly odd. Anyway, if somebody can help me, is whether this is a head note or whether it's effectively the court itself summarising its judgment, namely that it has no application where there's a dispute of foreign judgment.
Yes, my lord.
That's how, at the moment, I read it as part of the court's judgment.
My lord,
An introductory summary of the conclusion.
the experts who are both here are behind me discussing it at the moment, so perhaps I can
Right. Okay.
come back to you on that.
Thank you.
And then perhaps if I can just touch on my learned friend's point that, my lord, I'm informed that it is just a head note.
Yeah. Yeah.
So that may be the genesis of the reference.
Understood. Thank you very much. Yeah.
If I can deal with my learned friend's point in his skeleton and in argument that he's not bound by the decisions in Allianz and IGPL, he's argued that they're distinguishable on the grounds that there's no actual pending petition before the USC, or there was no actual pending petition before the USC in those cases. In my submission, you are bound by those decisions. The preconditions to engagement of Article 60 need to be established, not just the filing of a petition in order for Article 60 to be engaged, and that's in our skeleton argument. And therefore we say those decisions should be followed, and as your lordship himself remarked in argument, both the decision in Allianz and the decision in IGPL have the benefit of input from the US law qualified judge. I should perhaps correct a part of our skeleton argument. The question was raised whether the judge had the judgment in front of him at the time. That is, to be fair, an assumption on our behalf, but he must have read it, the decision at some stage prior to giving his judgment, you would assume. So that
Yeah.
with Allianz and IGPL.
Thank you.
Perhaps if I can turn next to what I call the applicant's 3 limbs argument.
Yeah.
And you'll have seen, I don't need to take you to it, Dr. bin Hazim's expert report that appears to indicate a clear indication not to abandon jurisdiction is required. It's not clear how the Dubai court has given a clear indication in the current proceedings. In fact, they've issued no decision confirming jurisdiction. And in my submission, there is no basis for asserting that there's been a clear indication or even an intention not to abandon jurisdiction. There's merely been, as we learnt today, an adjournment. For the 3-limb argument, Dr. bin Hazim relies on the Maidan case, and perhaps I can take you to Dr. bin Hazim's report, at tab 6.
Yeah.
That's 727.
Yeah.
And you'll see that he relies on what halfway through 727 is described as the 3rd requirement set out by the USC in the Maidan City matter.
Well, that's a rather strange reference to the timing after the matter is referred to the USC. But more importantly, it reflects the author's view that there must be a decision of the judicial authority.
That's correct. And in my submission, and this is paragraph 22 of my skeleton,
Yeah.
and 23, Dr. Benazir is placing too much reliance on the final sentence, and it's quoted at paragraph 22 of my skeleton from the non-attested translation of the USC case. It's highlighted in bold at paragraph 22.
So now that's a citation from USC case number 2.
Yes, it's a citation.
And that's divider 12, is it? No. Divider 13. No, it's a different case. Well, I don't know if that... USC case number 2, which is that?
That's the Maidan case, Your Honour.
Oh, it's Maidan. Okay, I follow. Yeah, I got it now.
Sorry,
Yeah.
just to give you the reference, it's tab 17,
Yeah.
page 226.
So this is yet, there's another marginal differentiation of translation.
That's correct. But
It separates out the last phrase, doesn't it?
yes, and that's where the third limb comes from, appears to come
Right,
from.
okay.
And we say,
Yeah, right.
paragraph 23 of my skeleton, that Dr. Al-Mullah's interpretation of the same sentence makes it clear that that sentence is not an independent basis for a conflict of jurisdiction, but simply elaborates upon the requirements of a positive conflict of jurisdiction. And the reference to that is paragraph 20 of Dr. Al-Mullah's report. I don't need to...
Okay, I understand the point. Thank you.
And then perhaps if we go to the USC law itself,
Yes.
which is at tab 12, Article 16, page 123.
Yes.
And of course, it's important to remember that we're all looking at an English translation of the Arabic original. And I just wanted to draw attention to so the three limbs argument advanced by my learned friend is that the first limb of his argument, which relates to the court not having abandoned the hearing, is not, he says, is not addressed at two conflicting judgments because that's dealt with by limb 3, the contradictory judgments limb. And therefore, our argument renders limb 3 otiose. In my submission, if you look at the final paragraph of Article 60, and it reads, the competent court of the Supreme Court shall order the stay of the execution of the contradictory judgments until the enforceable judgment is determined. In my submission, that should be read, the reference to conflicting judgment is in fact a reference to conflicting judgments on the subject matter. And I think your Lordship has alluded to this in his discussion with my learned friend. So in my submission, it's a reference to a substantive judgment, and that's reinforced by the reference to execution. Because, of course, execution relates to a substantive judgment,
Understood.
not to a judgment on jurisdiction. You have the point, my Lordship. And I say that the effect of the applicant's arguments on this three-limb test, as your Lordship has already alluded to, is that Article 60 could be simply engaged and the mandatory stay obtained simply by filing parallel proceedings in the non-DIFC UA courts, and prior to obtaining a judgment on jurisdiction in those parallel proceedings, in circumstances where the DIFC courts, as in this case, have already given a final judgment on jurisdiction. And in my submission, that cannot have been the intention of the legislator, as the parallel proceedings could effectively be used to torpedo the prior extant proceedings, to use a phrase that will be well known in the European jurisdictions, where a final judgment on jurisdiction has already been given in the extant proceedings, and that, in my submission, is not conducive to the administration of justice, and as Dr. Muller says in his report, would amount to a denial of justice. And finally, on this Article 60 point, I could just pick up on a point that was raised by your Lordship in argument with my learned friend. My learned friend makes a point of paragraph 55 of his skeleton in terms of the practicality of my where he says that an objection on jurisdiction will only be decided by a final judgment. Well, as your Lordship has already picked up, we've seen in this case that that is not necessarily so. There have been, and I appreciate the Lordship doesn't have the chronology, at least 4 occasions in the onshore proceedings where a decision on jurisdiction has already been given without a decision on the merits having been given. And I can give you the dates of those decisions. So on the 31st of May...
Well, they're in other cases, presumably, are they?
Yes, they're in the Sharjah court proceedings. They're all in the Sharjah court proceedings.
I've got 3 there, yeah.
So my point is that it isn't necessarily the case that...
Yeah, I understand.
my Lord, those are my submissions.
Very helpful, thank you.
Article 60 point. Is there anything else that I can assist you with on that?
No. Now, the case management considerations are not relevant because they're not being relied upon. You say this is an abusive process.
Yes, my Lord. Paragraph
Yes.
31 onwards.
Yeah, I have that in front of me. Yeah. Let's just think how we're going to deal with that.
Essentially, we say, as has been alluded to, that this application should never have been brought. The applicant has put the cart before the horse by making this application prior to a conflict of jurisdiction having arisen. Your Lordship has remarked that is a quite remarkable proposition, and in my submission, it needs to be looked at in the context, in the overall context of these proceedings, which were started almost 2 years ago, and we are still dealing with issues of jurisdiction and attempted stays almost 2 years later. That cannot be conducive to the administration of justice, which is one of the tests identified by the Chief in the DMB case in this court of paragraph 36 of my skeleton. As your Lordship has also identified, this type of application may have an impact on a number of other cases, and in my submission the court has an opportunity to send a strong message to the legal community that this type of behaviour should not be tolerated in circumstances where we already have had 3 sets of parallel proceedings. We've already had an application for a stay in this court that has been rejected, and in my submission there has been no material change of circumstances since that previous application to justify the current application. And as I say, it is premature, and it may not be, the timing may not be a coincidence, given that my client's immediate judgment application was issued on the 16th of May 2016, and this application followed shortly afterwards, coincidentally or not, on precisely the same day that Decree number 19 was issued. That's the same day that this application was issued.
Okay.
So that, in a nutshell, those in a nutshell are my submissions on abusive process. You'll see my skeleton has a section on
Yes, I have that.
objectives of the court, which is wrapped up into the same submission. I don't know if there's anything I can help you with on that.
No, I have that well in mind. Thank you very much.
those are my submissions.
Thank you very much. Yes. Any more? Yes.
May I have just one minute to take instructions, if I may, before making very brief, less than 5 minutes of reply submissions, if I may?
Okay, sure. So I'll just disappear for a couple of minutes.
Okay.
Is it convenient to come back?
My Lord, yes. My Lord, yes, indeed. I'm grateful for the break.
Sorry, let me just shut the door.
Yes.
My Lord, I'm grateful for that. My Lord, in reply, just dealing with the 3 points very shortly, decree, Article 60 and abuse. On the decree, my Lord, we say that the decree was clearly addressed both at the Dubai courts and the DIFC courts. It's therefore clear that the CPC cannot apply to it in terms, given that it does purport to regulate the judicial authority by reference to the judicial authority law of the DIFC. Therefore, ergo, we say the CPC does not apply. Furthermore, of course, we have your Lordship's points regarding the purported amendment of federal law, which I won't rehearse. My Lord, turning then to Article 60, in essence, my Lord, we say the law does not need to be concerned with a question of conflicting transliterations of the original Arabic, because the language, structure and purpose of Article 60 are clear. The tripartite argument, as I put it, doesn't come from my reading of an English text. It comes, well it does, but it comes from the reading of Article 60, not from some comment in a case, my Lord. And that interpretation, which is clear anyway, makes sense from the perspective of judicial economy and efficiency. One's looking, my Lord, at a legislation of 1973 of the Supreme Court, where the concern would have been to have parallel proceedings and the risk of contradictory judgments, which is why, my Lord, the USC statute makes it clear that all courts must stay their proceedings. That's the mischief, as it were, that this is addressed at. Now, I'm very conscious, my Lord, of course, of my learned friend's floodgates argument, but I think really what we would say there, my Lord, is that that is perhaps why, in the context of this error, the very reason why the ruler has passed the decree, but again, we say prospectively. My Lord, dealing very briefly with the suggestion that this application is an abuse, the court, of course, I won't take your Lordship to the authorities, but the court, of course, must look to both private and public interests and conduct. Looking at the private interests and how this matter has been dealt with, we say it's not an abuse. There's been a full defence on the merits filed in this case, not to mention also including claims for breaches of contract, we say, by the my Lord, we set out at the time where we said those breaches of the share claim that have been alleged in their particulars of claim ought probably to be addressed in the Dubai action. As your Lordship has noted, these are claims which could have been brought as cross-claims in these proceedings. So, my Lord, we say it's far removed from a case of guerrilla tactics. And as regards the suggestion in relation to timing, that this is convenient because it coincides with their judgment for immediate application. Well, the first point on that, my Lord, it was only after the proceedings ended in Sharjah, which was on the 16th of December last year, and then the parties filing their pleadings in this case, including our defence, my Lord, on the 6th of April. It was only shortly after then, around that time, my Lord, I should say, that the case was commenced in Dubai on the 30th of May. So the timing is based on what the Sharjah courts decided by directing us to go to the Dubai courts, not based on some attempt to stymie my learned friend's immediate judgment application. My Lord, I've already addressed the public interest in terms of the floodgates argument, and I think those submissions remain the same for the abuse. My Lord, those are my submissions in reply. Further.
No, it's very helpful. Thank you very much.
I'm grateful. Thank
you. Let me try and give a judgment. It's nearly the holiday period, and it's desirable that this matter should be resolved promptly. This is an application for a stay, the application having been taken up by the defendants, Investment Group Private Limited. The application is for a stay of the proceedings in accordance with Article 60 of Federal Law Number 10 of 1973, what might be called, for shorthand, the Union Supreme Court law. The Federal Law Number 10 sets out in Article 33 the jurisdiction of the Union Supreme Court, and one of the matters for which jurisdiction had been allocated to the Supreme Court is set out in sub-article 10, the jurisdiction dispute between a judicial authority in an emirate and a judicial authority in another emirate, or among judicial authorities in one emirate. It is perhaps worth noting in passing that what is being focused upon are disputes between judicial authorities. There's no dispute that the present potential dispute as between the judicial authority known as the Dubai International Financial Centre Court and the Dubai courts fall within the sub-article. There's no requirement for the dispute to be between judicial authorities of two different emirates. Article 60 reads as follows: in the event of a conflict of jurisdiction between two more of the judicial authorities referred to in Article 33, 9 and 10, that these authorities have not abandoned the hearing of the action, or that all of these authorities have abandoned the hearing the same, or issued contradictory judgments thereon, the petition for designation of the competent court shall be submitted to the Supreme Court by virtue of a petition based on the demand of one of the litigants or the public prosecutor. It then goes on to deal with the form of the petition and also to deal with the outcome in the event that there is a stay of execution of contradictory judgments until a enforceable judgment is determined. Again, it might be noted in passing that what is contemplated by Article 60 is a conflict of jurisdiction between two or more judicial authorities. The focus of the submissions made on behalf of the defendants, who are the applicants in the present proceedings, is that there is a conflict of jurisdiction between two or more judicial authorities, because proceedings have been issued in the DIFC and parallel proceedings have been issued in the Dubai courts, and the applicants or the claimants have not abandoned the hearing of those claims. The principal response of the claimants is that that constitutes a wholly unreal construction of the federal law. As I understand it is submitted, and I have sympathy with it, that any purposive construction of Article 60 requires the identification of a stance adopted by two or more judicial authorities and not a reliance upon the stance adopted by the parties to the proceedings brought before those judicial authorities. The chronology of these proceedings is also somewhat instructive. It is a very substantial claim that the claimants are bringing, namely a claim on two loan agreements totaling 184 million United States dollars. There is a cross-claim which is fairly minor in comparison, whereby the defendants assert there has been a miscalculation of the interest due on the loans, and that a sum of something in the region of 200 million dirhams is owed by way of damages. The claim that the claimants pursue was issued in the DIFCC on the 6th of August 2014, and that almost immediately prompted a challenge to the jurisdiction of the DIFCC by the defendant on the 21st of September. A few months later, on the 12th of January 2015, the defendants issued proceedings in Sharjah, pursuing what I have indicated to be their primary case, namely a miscalculation of interest and a claim in respect of damages. A few days later, the application made to the DIFC to challenge jurisdiction was refused. Equally, on the 31st of May, the Sharjah courts rejected jurisdiction. That decision was approved by the Sharjah Court of Appeal on the 15th of September, and in turn the appeal to the DIFCC Court of Appeal was dismissed on the 19th of November. The defendants went on to the Cour de Cassation in Sharjah, and that appeal failed on the 29th of December. At last, proceedings in the DIFC substantive proceedings got underway. On the 10th of February 2016, the points of claim were served. On the 6th of April, there was a defence, and on the 18th of May, a reply, together with an application by the claimants for immediate judgment. In the meantime, the defendants had sought to institute proceedings before the Amicable Dispute Centre in Dubai. This, in fact, was then transferred to the Dubai courts, the claim being advanced on the 30th of May, in precisely the same terms as those that had been pursued in Sharjah, but for which the Sharjah at all three levels had refused to entertain. On the 6th of June 2016, the defendants made an application to the Union Supreme Court for the determination of the alleged conflict of jurisdiction and for a stay. On the 9th of June, the defendants issued further proceedings in Dubai, in the DIFCC, this time for a stay under Article 60. That is the application which I am determining today. Coincident with that application, Decree number 19 of 2016 was issued in Dubai, which constituted a judicial authority to which I must return. On the 24th of July, an application under Article 60 was also preferred in Dubai. Today is the 28th of July for the hearing, which is being undertaken by way of video link with Dubai. It was also anticipated to be a day upon which the Dubai courts would rule on jurisdiction. There has been apparently an adjournment of that ruling until at least the 18th of August. I say at least because it appears that the adjournment was prompted by an application by the defendants to allow the opening of the pleading in order to put forward what is described as an essential defense. Now, the first issue that arises before me is the question whether the effect of the new decree is to eliminate the jurisdiction of the USC to determine conflicts of jurisdiction. What the claimants say is that it does, and that it has retroactive effect, and that accordingly this court has in effect no jurisdiction to entertain the application under reference to Article 60. The court should refuse to entertain the application and leave matters to be decided by the committee. The defendants agree, as I understand it, that the effect of the decree is to effectively amend the jurisdiction of the USC, but that, they say, is of no consequence because the decree does not have retroactive effect, and accordingly matters have to be considered by reference to Article 60 and not by reference to the decree. The decree does indeed afford to the judicial authority, the formation of which is set out in Article 1, responsibility and jurisdiction to determine conflicts of jurisdiction between the Dubai courts and the DIFC courts. And once its competence is engaged, then the conflicting claims will be stayed until the judicial authority issues a resolution that has to be produced very promptly. As I've indicated from the chronology, the decree was issued on the 9th of June 2016, that is to say 3 days after the application to the Union Supreme Court was made, and for that matter on the same day as the present application. As regards the issues that, in regard to the effect of the decree and its retroactive effect, I've had the particular advantage of expert evidence from 2 very distinguished jurists from Dubai who have prepared extensive reports. Dr. Ahmed bin Hazim has filed a report and opinion on behalf of the defendants, and Dr. Habib Al-Mullah for the claimants. And I must express grateful thanks for the clarity and quality of the reports that have been produced. As I've indicated, as regards the first point, i.e. the impact of the decree on the USC law, they are in fact agreed, namely that the impact of the decree is to eliminate the jurisdiction of the Union Supreme Court in respect of disputes or conflicts of jurisdiction between the courts of Dubai. I hope they will allow me to approach that agreement with some degree of caution. This is a very new decree, which is not without controversy. It has attracted a fair bit of academic discussion, including on the very topic that we're considering at this moment, namely the relationship between the decree and the USC law. The issue is, it seems to me, of some high level of importance from the perspective of both the Dubai courts and the DIFC and the judicial authority. One can't help expecting that issues may arise as to whether, as a matter of constitutionality, a decree of the Emirates of Dubai can override, or indeed amend, a federal law. If I can, I fear I would be minded to reserve my view on this topic, not least because it arises in a number of other cases. I accordingly may have to return to it, depending on whether it seems I conclude that the issue is important. As to the issue of retroactive effect, again, on this topic, there is a dispute between the experts. Dr. Mullah relies upon the federal CPC in support of his opinion that it is retroactive as being a procedural matter. Dr. Hazim prefers the view that it is not a procedural matter, but that the federal CPC is of no application, and in any event, even if the federal CPC was pertinent, there is an exception in respect to permitting procedural matters to have retroactive effect where the pleadings are closed, as indeed they are in the DIFC action. Again, I hope the experts will forgive me, as if I want to exercise caution and reserve my view on this dispute, which again arises in a number of cases. I'm not sure I find the point entirely easy. I won't even indicate which I would be minded to prefer at the moment. I consider the appropriate way forward is for me to consider whether there is in fact a conflict of jurisdiction, and only if I was to conclude there was, return to the issues of the retroactivity and the impact of the decree. Accordingly, I turn to the principal issue in this case, as to whether Article 60 is engaged. The claimants assert that absent any positive decision by both the Dubai courts and the DIFC courts confirming or adopting jurisdiction, there is no relevant conflict. The respondents contend that it is sufficient for jurisdiction to have been invoked by each party and not abandoned. And once that invocation in two different jurisdictions is established, there is a conflict. I've already drawn attention to the terms of Article 60, which seems to me to provide a measure of support for the claimant's position, given that it is directed at conflicts between two judicial authorities and not conflicts between parties as to which of the jurisdiction they prefer. At first blush, the article does require more than invocation of jurisdiction. I would shy away from allowing such an opportunity to create a conflict of jurisdiction. Such would occur without any input from the relevant judicial authority and would allow a reluctant defendant to put into the long grass a claim, maybe a good valid claim brought against him, by the simple device of issuing proceedings in another emirate and then claiming that there is a conflict of jurisdiction, thus creating the need for a stay and creating the need to await a decision of the Supreme Court, which no doubt would take a considerable period of time to emerge. The starting point in considering whether these first impressions are correct is to look at the decisions of the Supreme Court itself. Two decisions have been to my attention. First, an unnamed decision called Challenge Number 10 of the year 28, a hearing which took place on the 5th of May 2002 before the Supreme Federal Court. The headnote to the decision in the sorry, just give me one moment. The headnote to the decision is of some interest. Against, quotes, international jurisdiction, close quotes, it reads, dispute of jurisdiction, Supreme Court, jurisdiction of the Supreme Federal Court to decide in the dispute of jurisdiction between two final judgments shall be restricted to the disputed jurisdiction between federal judicial authority and the judicial authorities in the emirates, or between judicial authority in an emirate and judicial authority in another emirate. It shall not be expanded to include dispute foreign judgment and a judgment issued by the national judicial authority. Its base, its effect, judgment should be passed not to accept the case. That reference to two final judgments emerged in due course in two decisions of the DIFC, which I will come to in a moment. But in the body of the judgment, and I'm reading from page 134 of the translation, there is this passage. Having referred to Article 60 and to Article 33, the court went on, the meaning of these texts that the state of the disputed jurisdiction doesn't exist unless jurisdiction is disputed between the federal judicial authority and the judicial authority in emirate or judicial authority in another emirate, or between the judicial authority in an emirate between them, where each of them claims its jurisdiction to hear the case or give up its hearing, or each of them issues judgment in the case that contradicts the other. Now, the importance of that passage is that at the heart of the defendant's submissions to me is the emphasis that is placed upon what is said to constitute three separate circumstances in which a conflict of jurisdiction may emerge. One, that the authorities have not abandoned the hearing. Two, that the authorities have abandoned the hearing. Or three, issued contradictory judgments. As I read the decision in challenge number 10 of the year 28, what the emphasis is upon what the judicial authority in the individual emirate is claiming. The judicial authority claims jurisdiction, or gives up jurisdiction, or issues a judgment. There's no indication whatsoever that it's sufficient simply for a party to invoke jurisdiction and thus effectively preclude any decision by the judicial authority. It is, I suppose, fair to say that given perhaps a rather English approach to issues of jurisdiction, it may be surprising that there could be an insistence on a assertion or decision by the relevant judicial authority not to abandon the hearing of an action, a decision that might usually form a judgment, when there is already reference to a situation in which there are contradictory judgments. I'm minded to accept the submission made on behalf of the claimant that, be that as it may, that doesn't detract from the requirement for a positive assertion or abandonment by the relevant judicial authority. It may be that the reference to contradictory judgments, in contrast to decisions not to abandon jurisdiction, is designed to deal with a circumstance in which an issue of jurisdiction is dealt with in the course of a judgment on the merits. The other decision of the Supreme Court is in Maidan against Banyan, a decision dated the 23rd of December 2015. There are, in fact, two translations of the relevant passage in the judgment. I'm not sure that the difference between them is particularly significant. The translation that is in the agreed bundle, the passage in the agreed bundle reads as follows: turning to the merits of the challenge action, the Federal Supreme Court has held that a negative conflict of jurisdiction would arise when two judicial bodies before whom a claim is brought in respect to the same subject matter decide that the matter falls outside their remit and accordingly decline jurisdiction. Now, that is not this case, but one has to emphasize the verb decide. The passage goes on: a positive conflict of jurisdiction arises when two judicial authorities whom a dispute is brought in respect to the same subject matter assert jurisdiction based on their remit. neither body gives up jurisdiction, which justifies recourse to the challenge court to determine the matter by designating the competent court. However, this requires that a case be simultaneously pending before both disputant bodies, where they have both asserted their jurisdiction over the matter and did not decline jurisdiction when the matter was referred to the authority entrusted with designating the court competent to hear and decide it. And again, the present case is probably a good example of alleged positive conflict of interest, but this requires that both disputant bodies, i.e. the DIFCC and the Dubai courts, both assert, and I emphasize that verb, their jurisdiction over the matter, and don't decline jurisdiction when the matter is referred to it. This seems to me to, again, strongly emphasize the requirement that there be a positive assertion or decision by the relevant authorities to exercise jurisdiction. The alternative translation to that passage separates out the last phrase, and thus it reads, thus justifying an application to a court on matters of conflict of jurisdiction for determining the competent foramen. However, this requires the existence of a dispute pending at the same time between the two courts, both of which confirm jurisdiction to entertain such proceedings. There is a difference in the way in which that phraseology is phrased. That phraseology is set out. But again, I see no difference in the impact of the court's decision. There must be a dispute pending in two courts, both of which, i.e. both of which courts, confirm jurisdiction to entertain the proceedings. That is not this case. The only court that's asserted jurisdiction to exercise jurisdiction is the DIFC. The Dubai courts have made no observation on the topic at all. So in those circumstances, I am unable to accept the proposition advanced on behalf of the defendants, which is set out in their skeleton as follows. What is required is that there be simultaneous proceedings where jurisdiction has been asserted in each. Given that Article 60 can be engaged if the disputant judicial authorities have not issued judgments because of the not abandoned hearing of the action limb, the question is, what does asserting jurisdiction mean if, as it is, it must be something other than rendering a judgment on jurisdiction? The defendant submits that this must mean the court's jurisdiction has been invoked and the case is not being abandoned. This argument is consistent with the fact the way in which the court gives effect to a positive decision to assert jurisdiction is to pass a judgment. Accordingly, to give meaning to the third limb of Article 60, it must refer to something other than passing a judgment. The plain and ordinary meaning is that the jurisdiction has been invoked and has not been abandoned. I regret I'm quite unable to accept that the plain and ordinary meaning is that it's sufficient for the jurisdiction to be invoked, leaving aside the rather remarkable implications that would bring in its train if it was right. Even the expert called or tendered on behalf of the defendants falls shy of proposing that jurisdiction, the invocation of jurisdiction, of itself is sufficient. He identifies the requirement for, quotes, a clear indication, close quotes, from the court. And here, the Dubai courts have given no indication whatsoever, let alone a clear one. The claimants also relied upon two decisions of the DIFCC. Firstly, Alliance, in which His Excellency Judge Al-Madani gave the judgment of the court, and he made reference to the decision number 10 of 28, where his interpretation of the decision was to the effect, quotes, "This principle states the USC shall exercise its jurisdiction to determine the conflict of jurisdiction between two final judgments of a federal and local judicial authority, or between two local judicial authorities in the UAE." That passage was adopted by the Court of Appeal in the present proceedings between the defendant and the claimant. It's not easy, I confess, to identify precisely from where that quote is derived, given the translations that are before the court. But the principle that there has to be a decision, an assertion by each individual authority, and a final one, seems to me to be entirely proper. Otherwise, there is nothing to require the invocation of assistance from the Supreme Court in order to resolve the conflict. Furthermore, it strikes me strongly that regardless of the accuracy or otherwise of that citation, I am bound by the decision in IGPL against Standard Chartered Bank. The alleged distinction, as a matter of fact, between that case and the present case, namely that in the present case a petition has actually been issued for the USC, is not, in my view, a material distinction. So accordingly, I have reached the firm view that this application must be refused, and on the grounds that there is no conflict of jurisdiction. And I reach that conclusion with some satisfaction. Firstly, because it renders it unnecessary for me to determine the issues of the impact of this decree on the federal law, and the issue as to the retroactivity or otherwise of the decree. By the same token, I reach this conclusion willingly. The defendants have pursued almost every avenue to avoid the jurisdiction of this court and the determination of this very substantial claim. They've expended money in 3 courts in Sharjah, 2 courts in Dubai, or rather 3 courts in Dubai, and now the Union Court, the Union Supreme Court. This application is refused. Right, now, the form of order is clear enough. Or does anyone want to say anything about costs?
Yes, Your Lordship, you won't be surprised to hear that I do. Just before that, I note the Lordship's comments at the end there that there was a submission on my behalf that this application was an abuse of process. I don't know whether those comments at the end were aimed at that submission.
No, I should say that having dismissed the application, it seemed to be unnecessary for me to embark on the issue as to whether it had any validity or not. It was an abuse, but certainly my observations have some pertinence to the issue of the nature of any cost order that I may make.
Thank you, Your Lordship. I'm grateful. And on that point, you'll be aware, of course, of the practice direction number 5 of 2014, and obviously, as Your Lordship has refused the application and my submission, we should be entitled to our costs. And I say, given the comments that Your Lordship has made at the end of the judgment, that those costs should be on an indemnity basis. Practice direction 5, and I refer to it in paragraphs 45 and 46 of my skeleton, and it's paragraph A4 of the bundle. I don't know if you need me to take you to that.
Yeah.
Your Lordship. You'll be familiar with it. Provides that for an award of factors that will be taken into account when considering an award of indemnity costs, and those include in subparagraph 1 factors where the case or the conduct of the parties, the phrases takes the situation away from the norm, and then subparagraph 3 where the court considers that the paying party's conduct to be an abuse of the process. In my submission, that is clearly this case under either of those limbs, in circumstances where, as the Lordship has remarked, these proceedings were commenced almost 2 years ago. The defendant has taken almost every single avenue available to it to delay the consideration of this substantial claim. The claimant has relied on, has sought to bring the application prematurely in circumstances where a previous application has already failed, and in the knowledge of, as Your Lordship has just referred to, binding Court of Appeal authority. So in my submission, this application was always bound to fail in those circumstances, and award and demonstrate is appropriate. You may want to hear from my learned friend on that, but there is also you'll be delighted to hear a statement of costs as well, which I hope you have in front of you.
Yeah, I have that in front of me. Yeah, thank you.
You may want to deal with the principle first.
Well, let's deal with the principle, yes.
My Lord, we don't dispute there's a cost order against us. We lost on all points save for abuse, but I don't take that issue. We're obviously liable to pay costs. The question is, ought it to be on the indemnity or the standard basis? My Lord, we of course recognise the comments Your Lordship made at the end of his judgment just now. Nonetheless, we do say there hasn't been a finding in relation to abuse. Furthermore, my Lord, we would submit the language of Article 60, and some of the questions regarding the translation is not made this easy, despite what my learned friend has said. So, in those circumstances, my Lord, and given the clear language of Article 60, we would suggest that it was reasonable for us to have brought this application, particularly in circumstances where the buy application was itself one which followed on from what the courts of charge had directed our clients to do. So in those circumstances, my Lord, I would submit that the cost should be ordered on a standard basis, particularly taxes, if not agreed.
Yeah, I regard this as a long way from the norm. I would categorise this as a hopeless application, which was utterly devoid of any merit, and certainly devoid of any good purpose. And I regard this as a circumstance in which the cost should be on an indemnity basis, although whether that really makes much difference in the long run, given that that only bites upon the burden of proof in regard to reasonable incurring of cost. This is not a case in which proportionality is likely to be material, given the sums at stake. So the claimants may have their costs on an indemnity basis. I have the schedule in front of me. Are there any comments about that schedule?
My Lord, no. We have no observation.
No. Mr. Abbott, I'm reluctant what I call tax cost on the hoof. given you your award of indemnity costs. I think the right approach is to give you a substantial payment on account payable within 14 days. And so I order that the defendants pay $90,000 on account, the balance to be determined by the registrar.
If not agreed, presumably.
If not agreed, yes.
Thank you.
Anything else? No.
No, Your Lordship.
Well, thank you both very much for the efficient way you've disposed of this matter. The video link seems to work quite well, and I look forward to seeing you in Dubai later in the year. Thank you very much. Don't stand on ceremony, I'm just going to pack up my stuff.